Good afternoon, everyone. My name is Dahlia Hussein, and I'm an advocacy program manager at the Center for Constitutional Rights. On behalf of CCR and our partner, Albany Law School, I'm thrilled to welcome you all to today's event, What is the Role of Lawyers During Crises? Where we're also celebrating the launch of the new book, Crisis Lawyering, Effective Legal Advocacy in Emergency Situations. The book is dedicated to the late Michael Ratner, former Center for Constitutional Rights lawyer and president, who was a friend and a mentor to so many. If you're interested in buying a copy of the book, we have a code to receive a discount from NYU Press. It should be in the confirmation email you received about the event, and we'll also include it in the thank you email. Many thanks to all the speakers for making the time to be with us today, and thanks to all of you who are tuning in for this virtual conversation. We're so lucky to have legal commentator and senior editor at Slate, Dahlia Lithwick, join us to moderate the discussion with crisis lawyering contributors. Bahar Azmi is the legal director at the Center for Constitutional Rights and author of Crisis Lawyering in a Lawless Space, Reflections on Nearly 2 Decades of Representing Guantánamo Detainees. Lee Wong is the director of strategic initiatives at the Immigrant Defense Project and author of Crisis in the Courts, the campaign to get ICE out of New York State courts. Munir Ahmed is Deputy Dean for Experiential Education, Saul Goldman Clinical Professor of Law, and Director of the Jerome and Frank Legal Services Organization at Yale Law School. I hope I got that right. And the co-author of Call Air Traffic Control, Confronting Crisis as Lawyers and Teachers. And Ray Brescia is the Honorable Harold R. Tyler Chair in Law and Technology and Professor of Law at Albany Law School. He's also co-editor of Crisis Lawyering. Our speakers today are lawyers, advocates, and storytellers, and bring expertise and deeply personal experience to the issues we'll be discussing. We look forward to learning from their wisdom. So I have a few house rules to go over before I turn things over to Dahlia. We're recording this event for use by Albany Law School and the Center for Constitutional Rights. You can see we have Donna Jean Steele as our American Sign Language interpreter for today. Thank you, Donna Jean. If you'd like closed captioning, this webinar is enabled with this feature. On the bottom of your Zoom window, you will see a live transcript section, which you can click on and select to show or hide the subtitles. We'll have a chance to ask audience questions at the end of the event. So please use the Q&A feature on the bottom of your screen to type those in. Questions will be sent to and selected by the moderator, and we may not be able to get to all of them, but still encourage you to submit your questions throughout the event. Today's event has been accredited as a source of 1.5 hours of New York continuing legal education credits for both transitional and non-traditional attorneys. For those interested in CLE credits, you will need to fill out the affidavit of participation you received as part of the registration process. You will hear 2 codes given out during the course of the discussion. You must take note of those codes and insert them at the appropriate place in the affidavit. To receive the CLE credit, you must also attend the entire session. We cannot award credit, unfortunately, for those of you who do not attend the entire session, nor can we award partial credit. And please submit your completed affidavit together with the evaluation form you have also received to Albany Law School by emailing a copy of each to lriva@albanylaw.edu. And I'm sure that email address is also with the materials. So now, finally, I'm excited to turn it over to Dahlia Lithwick to kick us off. Thank you, and we're so glad to have you with us, Dahlia.
Thank you, Aaliyah. Thanks to all of you who are Zooming in. It's a true honor to be on a panel with these luminaries. And I'm really glad that in her introduction, Aaliyah described the folks you're gonna hear from today as storytellers, because one would not expect a big, thick book about the law to be kind of gripping narrative. It absolutely is. And particularly the folks whose chapters you're going to hear from are phenomenal at communicating really effectively and briskly about very, very complicated legal issues. And I take that very seriously because that's the thing I strive to do as a journalist every day. So I could not be more delighted to be asked to host. And as Aaliyah said, pop your questions in the chat, kind of starting, and I'm sorry, not in the chat, in the Q&A starting now, and we will try to leave ample time to get to them. But we've got a couple of kind of topic areas we want to cover before we do that. And I wanted to start by calling on Ray, both as co-editor of the book and as the person who co-wrote the foreword, just to explain by way of some table setting, Ray, what it is that we talk about when we talk about crisis lawyering. I'm sure there's an awful lot of folks, even on this call today, who aren't completely certain what that term of art means. And I note that in Munir's chapter in the book, he writes, quote, representation of clients necessarily involves coping with unanticipated emergencies, some of which require a form of crisis intervention by the lawyer. In other words, he writes, lawyering is crisis lawyering. And I suspect everyone on this Zoom today has been a crisis lawyer at some point. So could you kind of narrow the aperture, help us understand what is and is not in the bucket of sort of criteria for what you defined as crisis lawyering for purposes both of the book and the conversation? But you're gonna have to unmute.
Of course, it would happen once. I'm glad I got that out of the way. So thanks for that question, and thank you for agreeing to be with us today. It is our honor as well to have you lead us in this discussion. And I also have to thank others as well very quickly, the great folks at CCR, Aliyah Hussein and Obi Nuabuzor, as well as folks at Albany Law, Ben Myers, Bill Purcell, Lisa Rivich, Jeff Saber, and Tyler Seabridge, all who made work behind the scenes and just did an amazing job. The contributors too to this book, it's so exciting to hear you agree that these are great storytellers, not just the first team all-stars we've got today, but really everyone in the book has got a great story to tell, and it was a privilege to have lived with these stories for the last 3 years, as really sort of coaching them on the side and helping them bring their stories to life. Much of it required, I had one of the easiest jobs in the world. But I also want to say, the book is dedicated to Michael Ratner, from the Center for Constitutional Rights, who passed away 5 years ago. He was a mentor to many of the authors in the book, myself included. And I think that like Michael, the contributors who we'll hear from tonight and who contribute in the book generally, really represent, I think, the sort of highest ideals of the profession. And one of those, one of the roles that lawyers certainly play is, helping a client navigate through crises. What do we mean when we talk about crisis lawyering and the crises that lawyers face? So there is a sort of emerging field of crisis studies, and they look at several components of crises as presenting threats to values and safety, where the facts are uncertain, where the threats are unclear, and decision-making must take place in an accelerated time frame. Now, many clients turn to lawyers in these sorts of, in crisis, right? Lawyers are often the, maybe the first or second person that a client may contact when they face a crisis in their life, in their world, in their business, whatever it is. Not every client crisis is a crisis for the lawyer. Not to say that the lawyer isn't, empathetic, isn't concerned about, the safety of the client, but oftentimes the lawyer, prepares for handling just the type of crisis that the client presents, whether it's a deportation or an eviction, a foreclosure, a bankruptcy. In many instances, the client crisis is exactly the crisis that the lawyer has prepared for, her whole career. She knows what to do, when to do it, and how to do it. But the type of crises that we talk about in the book, that the contributors talk about in their chapters, really sort of fit under that, that broader umbrella I talked about before. They're novel challenges where the facts are uncertain, the path forward is unclear, there are serious threats to values and safety, and the lawyers and their partners in advocacy have to move quickly. And it's these sorts of crises that we really present in the book. And we'll hear from three contributors, dealing with representing clients on Guantánamo, combating and resisting the Trump travel ban, and trying to get ICE out of the courts. If you think about each of those crises, they are novel, they are strange, they are new, and they pose serious threats, and lawyers are acting under a great deal of uncertainty. And so these are just some of the crises that are covered in the book. We look also at climate change, the policing crisis, representing immigrants in detention, representing the homeless in New York City in the 1980s when there really were no legal rights for the homeless. So and many other chapters. And you see in the materials, folks have been given the introduction to the book, and so you can see the different chapters that we cover. And the purpose really behind the book, Dahlia, when we were talking before this, you wanted me to set the table. So I'm a former busboy, so let me set the table a little bit. They're first-person accounts of lawyers, but there really are also the stories of activists and allies and communities, and the purpose of having these stories told in the first person was for all of us, whether it's lawyers or those who work with them, to understand how lawyers in working with their clients and the communities they serve have brought about victories. They faced defeats, but really the goal is to take lessons from those experiences so that others can prepare for these sorts of crises from occurring in the future. I think something that really comes out in the chapters, and this is something that is so central to the work of the Center for Constitutional Rights and clinical programs and Immigrant Defense Project, putting clients and communities at the center of their work is so central to these panelists' experiences, but it's also for all of the contributors. And our speakers, like, as I said earlier, like Michael Ratner, really represent the highest ideals of the profession. They are true crisis lawyers. They're true movement lawyers. And I've read their stories. I've heard them speak before, and I look forward to all the conversations we're going to have tonight. I will mostly step back. You will see my whiteboard appear on occasion when I've got the CLE code that we've got to give to you. But without belaboring the point anymore, I hope the table is set for a great feast of a conversation. So Dahlia, back to you.
Thanks, Ray. That's perfect. And I think there are themes that Ray has sort of touched on that we're going to really try to pull out in this conversation. But I think that really helps differentiate what it is that we're talking about from what may be very, very stressful lawyering that is not necessarily within the rubric of crisis lawyering. Now we're going to just hear from each of the three authors, just to again do a little bit of tell us about the case that you wrote about. In Munir's case, it's two, but tell us a little bit about what is in your chapter, and maybe, you don't have to kind of do a discursion on everything in there, but give us a sense of one or two big themes that we can pull from your chapter. And we'll try to do this in sort of 4 minutes each, kind of lightning round, with the caveat that everyone has to read everything in full to get all the nuance. And why don't we start with you, Bar?
Hi. Thanks, Dahlia. I'm really honored to be in conversation with Ray and Munir and Lee. My book chapter is titled Crisis: Lawyering in a Lawless Space, Reflections of 20 Years of Representing Guantánamo Detainees. And it tells the story of an intervention by CCR lawyers led by Michael Ratner in response to a bona fide human rights crisis created by the Bush administration following 9/11, in which I think Guantánamo and the creation of a lawless prison was its crown jewel. And it speaks about this sort of initial effort where CCR was largely alone in January of 2002 in responding to this crisis in a moment of muscular national security flexing, and an effort to vindicate the very process of law and the pursuit of rights, and the recognition of these individuals through contestation in the courts. And as I note, in the initial filing, Michael Ratner speaks the fact that they were certain to lose in this political context, and that they filed 100% on principle. But after filing, a sort of funny thing happened on the way to the courthouse, which is some public narratives around the Bush administration changed. The Supreme Court in 2004 ruled in favor of detainees, at least in a narrow way, to suggest that they would have access to lawyers, if not necessarily, as we learned, a full, robust collection of rights. And then that created a momentum around building a huge coalition of lawyers, individual lawyers from across the country and to some extent across political ideologies, and an international coalition of activists, human rights scholars, the United Nations, and an even broader coalition that worked over a period of years to, I think, fundamentally destabilize and delegitimize Guantánamo, such that by 2008, 6 years later, both political candidates were saying they would close it. And the Supreme Court ruled in an ultimately, empty ruling, but at that time seemed momentous, that individuals would have rights, constitutional rights, these even in the national security space. And then I reflect that, here we are now, 20 years later, Guantánamo is still around. And it is actually, the system has been legitimated by law. It's been accepted by the courts. And that is a real troubling paradox. So part of what I try and do is reflect on why that happens and what that means for the very concept of law, and then what lessons we can draw as lawyers given the limitations of law in service of really politically disfavored people.
That was phenomenally concise and well done. That's a high bar for your co-panelists. Lee, let's do your chapter. And again, I think it's a version of the same story where there are just political headwinds that you are facing in your chapters, such that, much like we just heard, sometimes the big wins turn into big losses because they generate such political animus. So why don't you lay out what your chapter is about and a theme or two?
Thanks, Dahlia, and thanks for including me in this book. I have to say, after reading Bahar and Munir's chapters, I just felt incredibly humbled to be even included in this book because their lawyering is so just inspirational. But My chapter starts in 2017, almost exactly 4 years ago. So, early 2017, I think, was very much a moment of crisis for the entire country in many ways, but particularly for immigrants who are being targeted by the Trump administration. And at the Immigrant Defense Project, we have for many, many years run a free hotline for immigrants and attorneys alike to call and get advice, particularly on the prison to deportation pipeline, which is what we specialize in. And we started to get really a flood of calls reporting all kinds of really brazen ICE raids across the city, right? Like ICE bringing mobile fingerprinting devices to apartment complexes, ICE doing pre-dawn raids in people's homes, ICE setting up sting operations, pretending to be contractors. I mean, all kinds of crazy things. But one trend that became pretty clear around March of 2017 was that ICE was starting to use New York courthouses as bait for catching immigrants, right? So essentially, I'll give you an example. A legal aid attorney that I spoke to in 2017 reported, he was standing outside of the Manhattan Criminal Court on Center Street. This is just a few blocks away from City Hall, when he saw some plainclothes officers surround his client, sort of come out of nowhere, grab his client, and then shove him into an unmarked vehicle and speed away. And he, used the word rendition to describe what he saw, because I think he really did not have any other frame of reference for how to describe such an act of lawlessness, right? And that was what we heard repeatedly, that there were plainclothes officers that were stalking immigrants in the courts, not just outside of the court, but into the courtroom chambers, targeting folks who were charged with crimes, but also folks who were seeking protection from the court. So people who were survivors of human trafficking, people seeking orders of protection, people who were there for child custody hearings. And it had an incredible chilling effect, right? It had an incredible chilling effect on a community that was already being actively terrorized by the Trump administration. And I'll just say that, what followed was sort of a multi-year campaign, and I should have probably led with this, that actually ultimately was successful, which is incredibly unusual in this line of work, particularly for an organization like mine that fights for immigrants who have had contact with the criminal justice system. We almost never win, so this was a very rare win. But the sort of surge in this tactic, I think, brought to the fore a lot of really particular issues that I think we continue to grapple with. And one of them is sort of what are the limits of state power, which I know is something that comes up in for the other panelists. What are the limits of state sovereignty? How does a state respond? How does New York State respond when the federal government is actively undermining its court system, right? Actively undermining access to its judicial system. And then it was very much, I think, a crisis of lawyering. And I think this is something that I still don't know really where I land, but when I wrote this chapter, it was sort of at a moment of despair, I'll be honest, because we had been already engaged in the campaign for many years, and it really didn't feel like there was going to be a solution. And every day we were getting reports of people getting snatched from the courts. And it got so bad that lawyers actually started walking out, which is sort of, I think, an incredibly courageous act, but it was also a very controversial act. There were walkouts across the city in all 5 boroughs, and lawyers really actively putting their bodies on the line and engaging in civil disobedience to stand up against it. And I think it raised a lot of questions for me about what is the lawyer's role and what do you do when your legal tools sort of no longer seem to get you anywhere.
Yeah, and I want to get back to that because I think, Lee, you more than almost anyone on the panel really raises, I think, intractable questions about what happens when you're both an officer of the court and a lawyer to your client, and you are beholden to both. You are trying to do your, sort of duty by both of them, but you're crosswise no matter what you do. And it's just your anguish around that in the chapter is really clear. Let's pull in Munir to tell us a little bit about, again, your chapter and one of the sort of thoughts, big thoughts you have on crisis lawyering.
Great. Thank you, Dahlia, and thanks so much to you and Ray and CCR for inviting me to be part of this discussion. And I'm really delighted, especially to be here with Bahar, whom I've lawyered with in Guantánamo and elsewhere, and with Lee, whose work I've learned so much from in terms of what they're doing at IDP. I feel like we call IDP and email IDP relentlessly asking for advice in our cases. So it's really a pleasure to be able to be in conversation with them as well. So the chapter that I co-authored with my colleague Mike Wishney is about two cases, actually. One is a challenge to the Trump administration's first Muslim ban, and the second is our representation on behalf of an individual named Nuri Chavarria, who was seeking sanctuary in a church basement in the face of deportation in the early days of the Trump administration. I think for the sake of time, I'll focus on the Muslim ban, although I'm happy to talk about the second case as well. And so the chapter is focused both on what we did and what we learned as lawyers, but also as teachers, because Mike and I co-teach a clinic at Yale Law School, which, and it was through the clinic that we were involved in these representations. I'll say at the outset that, focusing on the teaching or the pedagogy side might seem a little bit parochial, although I think that part of what it was useful for us about it is that it helped us to draw out some lessons that are not really just about what do we teach first year or second year or third year law students, but how do we engage in lifelong learning and professional development as lawyers. So I hope that even the pedagogy sections will be useful to practicing lawyers and not just the lawyering sections. So I think that, in many ways, the history of the Muslim ban is well known, but this chapter focuses on essentially the first 24 hours. And so if people recall, the Muslim ban was announced and went into effect on January 27th of 2017. So it was a week to the day from the Trump inauguration. And what Lee was describing in terms of that sense of despair in those first days and weeks of the Trump administration certainly resonated with me. And what I recall from that period is that every day there was kind of a new announcement of something that was raising and jeopardizing a set of concerns and values that I had. But the Muslim ban was the first policy to be executed in a way that directly and observably harmed people. It left people at airports who were seeking to enter the country stranded and facing, in fact, worse than that, facing immediate removal and return, oftentimes to places where their lives were in danger. And so our chapter talks about the night that we got a phone call from Becca Heller and Justin Cox who were two of our former students working at nonprofit organizations, IRAP and NILC, saying that they had clients who were coming in from Iraq, who had visas that made them eligible to enter by virtue of their work with the U.S. military, and if they were returned under the Muslim ban, their lives would be in danger. And so, without kind of rehearsing all of the chronology, that began at 10 o'clock in the evening on a Friday night. And at 5:32 in the morning that Saturday, we filed a complaint for a nationwide habeas class action. By 8 o'clock that evening, we had an order from a federal district judge in the Eastern District of New York granting a nationwide injunction and halting the first Muslim ban. Obviously, there's a lot that happened in between, which again, I'm happy to talk about. But I guess in terms of the big ideas, I'll end on this. One of the themes I think that we're trying to engage on is what gets mobilized in a crisis. So we tend to think of, well, you're filing a lawsuit, so you mobilize the facts and you mobilize the law. But I think that part of what also gets mobilized in those moments is a set of moral claims. And part of what gets mobilized also is literally mobilization, people. And so to me, it is not coincidental that the order enjoining the first Muslim ban roughly 24 hours after it went into effect, it came not just by virtue of a lawsuit. That was the kind of the technical intervention that served up an opportunity. But actually, what most meaningfully transpired in those 24 hours was tens of thousands of people turning out at airports across the country. And in fact, turning out at the courthouse that evening, that Saturday night, showing up and filling the courtroom when the issue was being heard. So that, I think, raises a really important question about what the relationship is between lawyering in crisis and social movements.
And I will just note, I should have said it when I introduced you, Munir, but Munir's chapter, I think in some sense, gives you that heart-pounding, sense of like, this is really, as a descriptive matter, momentary decisions that have huge ripple effects, and this sort of very inchoate sense that you're trying to figure out, do we do a class action? Do we just represent our client? Like, these are the kinds of things that quite literally in the moment, there's no way of knowing what the cascade effects are. And so I think we're going to ask you to speak to that. Ray, do we want to do a CLE now at this lovely natural break? Okay. And Ray, maybe hold it up a tiny bit. So there you go. Okay. You would have to unmute. You good? Okay.
I was just going to say, we also can wait for the movie version of Munir's chapter to come out because it is very cinematic.
Let's start, and now we're just free for all. I won't call on anyone, you can jump in, but I want to start at this very granular question of who the client is and what your responsibilities are to the client. And this comes up in different ways for all of you. What I just said, Munir, maybe we could even just take that up, of this question that you were having to make about sort of the scope of the relief you were asking for. It comes up in Lee's chapter in terms of what you can disclose to your client if you're afraid they're going to be arrested. But maybe we can sort of just go through quickly and talk about how complicated some of these issues around who your client is specifically in these moments and what are the bounds of your responsibilities.
Dahlia, do you want me to start? So, this is one of those places where the representation actually, frankly, reminded me of the Guantánamo representation, because in both instances, we knew that there were clients out there, but our communication with them was incredibly indirect. And so we were filing lawsuits on their behalf, but really as next friends, without having spoken directly to them or having having them authorized it in that way. It was legitimately done through the next friend process, but necessarily done through the next friend process. And so that was already from jump, that was a place of disconnect with the clients, and placed us, I think, into a space of some abstraction. We were doing our best to tell our clients' stories, but we were relying upon the information that was being transmitted through various others. Our co-counsel, the International Refugee Assistance Project, and NILC, I think, they did have a history with these clients. So it's not that it was completely attenuated, but in the middle of the night, it certainly felt attenuated. And then, as you said, we made a decision also in the middle of the night, not just to file on behalf of these two individuals, but to file a class action, and not just to file a class action, say, for people coming into JFK Airport, but to file it nationwide. And I think in many ways, that decision came down to a middle of the night judgment that this might be our one and only shot. That it was possible that we could file our suit on behalf of the two individuals with whom we were in direct contact, and that it could be shot down, and that would be the end. And we knew that, of course, there weren't just those two individuals. There were thousands of people across the country who were in a similar predicament. So that was the judgment we made. But I guess I'll just say that that was just by nature of class actions that then also put us into a space of even, further attenuation from our clients, because now we were filing the lawsuit on behalf of people whose characteristics were known to us, but the people absolutely were unknown to us.
And Lee, do you want to talk for a minute on somewhat the same theme? You describe, what starts happening really quickly in 2017, that this pattern of events makes it difficult, right, for attorneys to even advise their clients who's at risk of being arrested, who needs to be warned, how should they be advised, what can you say and can you not say? So can you also weigh in on this question of how you're kind of meant to do your best service to your client, also within the really kind of catastrophic melee of what's going around it and knowing what the consequences could be for them?
Yeah, I mean, I think, on an individual attorney-client relationship level, it just was incredibly fraught for so many attorneys across the city, because what was happening was that, ICE was showing up virtually every day in some courthouses to pick people off. And there was no warning, right? There was no way to know. They were showed up in plain clothes. If you as an attorney suspected that someone was an ICE agent and asked the person explicitly, are you with ICE? They refused to disclose and refused to even provide identification. And I think a lot of attorneys struggled with, as an officer of the court, I cannot advise my client not to appear. But I also have a duty to advise them on the potential consequences of appearance. And I'll just highlight a really kind of awful moment that happened in April of 2017, where a group of ICE agents showed up at a special court in Queens that is a model actually for trafficking survivors around the country, where men and women who are accused of usually prostitution-related offenses are often, given rehabilitative services, or they're sort of a much more holistic approach to both the judicial process and to lawyering there. And they specifically targeted that part of the court, going after a group of Chinese women who were there facing charges. And the attorneys from Legal Aid actually made the really heart-wrenching decision of asking the judge to set bail on a client and having their client stepped in and brought to Rikers instead of risking being taken away by ICE. And that's, I think, the kind of decision making that a lot of lawyers face, right? I mean, do I send my client to Rikers, a notorious prison where, there have been years of human rights abuses, or do I open them up to the possibility of, deportation and permanent separation from their family? So I think those were the types of decisions that people really struggled with. And ultimately, I think some lawyers said, you know what, I cannot be part of this process. I cannot participate, which was what led to so many walkouts.
And Bahar, I want you to talk about the trust piece, because your chapter, what happens when you're sort of airlifted into a situation? There's no reason for your client in Guantánamo to trust you, and you have to kind of give him a letter that his mom has written. But can you talk about some of the same issues that Lee raises, which is building trust when it's really, really fraught for you and it's really unclear why this person should take you or this system seriously, is a huge part of the project.
Yeah, thank you. But when I'm thinking about Munia's reflection that there's an indirect relationship to the client, I think what's particularly fraught about Guantánamo was that the assertion of a client relationship was at the very foundation of the cause we were after. Let me say what I mean about that. So, Guantánamo was a total system with an authoritarian logic. It was created intentionally to evade the law, avowedly to evade the law and lawyers. This was never about sort of adjudicating guilt or innocence or even meting out punishment. It was part of a global system of detention and interrogation and torture, and outside the law, and to create systems of, in one CIA manual, dependence, stability, and dread, a form of sort of learned helplessness that we learn in Psychology 101, so that people become totally dependent on their interrogators. So, for example, when one of the 5 Bosnian detainees who were quite literally kidnapped after leaving a Sarajevo courtroom, having been acquitted of charges of terrorism, kidnapped by American forces, hooded, drugged, and sent to Guantánamo, when he asked for a lawyer, interrogator sort of famously said, "There is no law here, we are the law." And that was intentional, of course, because lawyers can stop interrogations, but I think lawyers and a lawyer-client relationship is the profoundly anathema to the whole system of Guantánamo, because what lawyers in theory can do is bring hope. Tell me your story. I will communicate to the outside world. I will fight on your behalf and represent your interests. And the whole system was designed to make sure that they would feel that help was never on the way. So yes, it was, when I met my client, he had not seen anyone who wasn't an interrogator or a military person. And as he told me later, he didn't believe for a second that I was a lawyer on his behalf. But as you say, I brought a handwritten note in Turkish from his mother that sort of melted him and kind of broke this like prism of totality. And then you sort of developed a relationship. I would say it was some of the early clients, the earliest clients were largely European through our connections with human rights lawyers abroad who were contacted. And so they at least had a sort of conception of the idea of the rule of law and having a lawyer. Later on, those processes became a lot more fraught when you're talking to, a rural Yemeni client who associates law with power and never law with rights. And so there were all sorts of particularized procedures to deal with that dynamic. But so yeah, that's what sort of getting a client-lawyer relationship was at the sort of heart of sort of shattering the system, as Joe Margulies would say. And that ultimately became to the extent there's any success story in Guantánamo, it's those individualized relationships and not a pursuit of rights.
Which of you wants to unpack a theme that Munir, I think, surfaced really early, but is such a through line in all of your work, which is these strange bedfellows and these coalitions and these improbable allies, and the ways in which it's really explicit actually in your chapter 2, Lee, that you're trying to make determination between groups that are not always the priority of every group, and how we work that out, and how important it is, because I think Munir's right. It's clear that each of these successes, even the not successful success at Guantánamo, is a function of building coalitions in very unlikely places, and sometimes subordinating you or your client's interests to something bigger. Does anyone want to sort of tee off on that as a question? Because as lawyers, we're not taught necessarily to be organizers.
I could just start off. I mean, I think that, I think that for folks at IDP, we have for so many years worked with a population of people who are really considered politically dispensable, right? I mean, they're sort of on the margins of an already marginalized community, right? They are immigrants who have criminal convictions. And I think that for us, we entered this sort of work and the coalition building, I think, with skepticism and suspicion, frankly, of groups that we often saw as our adversaries. So for example, folks that represent survivors of intimate partner violence. But it was actually those relationships that I think were really very much key to unlocking that logic that ICE was using and helped us to really pierce this very sticky narrative of public safety, right, that ICE uses. And to me, that was actually like the real power of the campaign ultimately, is that we were able to see through and help people see through the kind of perverse logic that ICE was somehow protecting us by making people scared of going to court. That was fundamentally their claim, right? That like they were making all of us safer by picking people off. And I think that the ability to kind of build solidarity with those unlikely partners was really key. And I'll just like note a really key decision point for the coalition was kind of about a year into the campaign, after a lot of pressure from state chief judges around the country and from nonprofits and from elected officials, ICE finally announced a policy around courthouse arrest, where essentially they said, okay, all right, yes, we do have a policy of targeting people at courts, but we won't go after people in civil courts, unless extraordinary circumstances demand it. And there was a real decision, I think, for us as a coalition, would we accept that as a compromise? And ultimately, we collectively rejected it. And that was I think it was a real show of power. And I think it was sort of a show of strength that ultimately allowed us to kind of make the full victory possible.
Any other thoughts on this incredibly challenging work of building coalitions across really divergent interests?
One thing I'll say, I don't know this so much about the divergence of the interests as just maybe not necessarily having the same focal point, but the circumstance, things were so fast moving with the Muslim ban. Obviously, Trump had made comments about complete and total shutdown. That was his language on the campaign of Muslims coming into the country. So it wasn't a total surprise. And there were some people who I think, had an earlier inkling that week that it was coming down the pike. But in terms of it kind of bursting into public view, it was very sudden. And so, as I said, the protests, I think, were enormously important as a political matter and in terms of the public speaking to the courts. But sometimes I think people at that time thought, oh, look at these spontaneous protests that arose all over the country. And while it's true that there was some spontaneity, there was a ton of organizing that had been going on for years and years and years among immigrant communities that was, this goes back to what gets mobilized, right? You can't build that on the fly. And so what I think did happen is you had immigrants' rights groups that may or may not have been focused, frankly, and most of them hadn't been focused on Muslim communities, but understood, recognized the way in which the Muslim ban was a kind of tip of the spear on an assault on immigrants more broadly. And there had been a lot of, particularly in places like New York City, a lot of coalitional work that had been done across communities. And so you had groups like Make the Road New York, which turned out a ton of people at JFK Airport, and the Taxi Workers Alliance that did actually have a lot of experience organizing Muslims and other South Asians, and they could drive people out in large numbers as well. So I think of this as also being, a question of when a crisis emerges, what are the capacities to deal with them? And organizing, I think, is when it exists, is such a deep reservoir to draw upon. But as anyone who's done organizing knows, or for those of us who are kind of, in proximity to it know, it's the day-to-day unglamorous work of knocking on doors and having meetings and kind of raising consciousness and doing small campaigns that then enables something very large to happen in a moment of crisis.
Yeah, I'm going to add the sort of unusual bedfellows coalition that developed around the Guantánamo work, I think came initially through an intentional framing of the question presented, which was not one in 2004 of the rights of terrorist suspects versus the quote, national security. That is not often a winning formula. It was one about vindication of the rule of law. And naturally, people could get behind that as sort of narrative that this is a rare and dangerous experiment. America has lost its way. And you can bring in a lot of coalition to sort of validate that gauzy vision of America. So, we had, the amicus strategy in the first Supreme Court case included former diplomats, former prisoners of war, retired generals, retired federal judges, a coalition of 200 plus English parliamentarians that said something like, America, so far you've done so good with our institutions, but you've got this habeas thing all wrong. You can't be doing this. And I think most evocative of all, an amicus brief by Fred Korematsu, sort of really fixing the rear view mirror of the court on 1944 and past mistakes. And then I think a very intentional decision by CCR and other lawyers to democratize the litigation and not have it held with one radical legal organization, and pull in every shape and flavor of lawyers, and also pull in international, and they were of course getting involved themselves, international organizations to continue to delegitimize Guantánamo. I mean, I think in retrospect, of course, and I think that was the right strategy at the time, or maybe the only strategy at the time. In retrospect, of course, you can reflect that, maybe Guantánamo is not so exceptional. Maybe Guantánamo is really, quite American. And there are probably threads that connect it to the Muslim ban, and of course the escalation of ICE and regulating the courts through immigration law.
I love that point, because it again draws on something you each flick at in your chapters, which is this language of this is not America, this is not what America is. It gets kind of co-opted in all sorts of pernicious ways that doesn't help the narrative at all. Ray, tell us about, I know that you want to talk about some other chapters where this issue comes up.
Yeah, just briefly, there are two other chapters that deal with this question of allies, unlikely allies, how to work with community activists. My colleague Sarah Rogerson's chapter on representing immigrants in detention in the Albany County Jail, where one of the strongest advocates for the interests of the detainees was the local sheriff who runs the jail, who knew that he had a humanitarian crisis on his hands, and worked hand in hand with the advocates to improve the jails, to such an extent that the federal government no longer sends detainees there because it's too much trouble. And then also sort of a little bit different is the chapter on that Christy Lopez writes on being one of the primary authors of the Department of Justice's Ferguson report, and sort of how to move into a situation like that where there's a lot of advocacy on the ground, and what the expectations are from an ally, that might be an ally today and an adversary tomorrow in the Department of Justice. So those are just, I think that this issue of allies and cooperating with the community and finding unlikely allies really permeates all the chapters, because I think it is an essential element of crisis lawyering generally.
I want to ask the panel one more question, and then we can turn to our last section, but it's something a little bit weighing on me as a journalist, because I think you each have elements in your chapter of, and the journalist stepped in and public opinion, showed up. And then there was a moment when we were the winners, but we were the losers. And sometimes we're the winners. And there's a way in which it not only raises, questions that I want to ask sort of just about how journalism gets it right and wrong, but bracketing that, I'm really curious about this timing issue, because it's clear to me that each of you tells a story in which at some moment you're a winner and you've got a window in which to do stuff. You know, Munir's got people running around showing their screen saying, you know, look, we've got an injunction. You know, Lee's got, this just happened. We got something here, and it's not clear how to communicate that. But also the ways in which the press helps you get that win. And then I guess in some sense, the tragedy of Guantánamo, which is the press got bored and walked away. And the situation just got reified and enshrined into law. So I think I want to ask this timing question the following way. What do we do with a news cycle that is unerringly episodic and shallow and very, very, very wound up for, 24, 48 hours, but is on to the next thing? And is there a way that you have all had to think about crisis lawyering as a function of this dance you're doing with very, very limited, fierce public engagement, and that window that sort of is closing almost as it's opening? That's a very existential question. I'm sorry for evening, but that's my question. Does anyone want to take a whack? No takers for existential? Okay.
Well, Bahar, why don't you start? Okay, so I mean, your question reminds me, Dahlia, of being a lawyer in Los Angeles in the late 90s, and I had worked on a very prominent sweatshop case in the garment industry where a group of Thai workers had been trafficked into the United States and enslaved, really, in this garment sweatshop. And it was one of the first cases to really expose the modern day phenomenon of slavery, labor, kind of exploitation of slavery in the United States, and also kind of put trafficking kind of in a new modern frame. And so after that case was done, I continued with the organization I was working with, the Asian Pacific American Legal Center in Los Angeles, to litigate garment sweatshop cases. And I remember pitching reporters about cases that we had coming up. And inevitably, the first question they would ask is, yeah, but was anyone enslaved? And so as soon as I said no, they lost interest. So it's a version of this. I guess, I'll say that one thing that I've thought about since the attention span is short, the window for media-driven mobilization is narrow. It does, I think, encourage us as lawyers to think about a way to align our legal tools with the rhythms of the media and of public attention. And this isn't something that I had any conscious awareness of at the time that we were doing the Muslim ban litigation. But looking back on it now, looking back actually in a number of cases from the Trump era in particular, I see the ways in which moving for a TRO or moving for a preliminary injunction it ended up being really good vehicles for trying to address crises and achieve some early success. And the reason in the Muslim ban case, I'll just stick with that, we, I think, styled a request for relief as a stay of removal, which was a little mushy to be honest about it, although to be fair, also a middle of the night kind of request for relief. The court essentially treated as a TRO. And the reason that was to our advantage is that we had to establish immediate irreparable harm. And once we were able to do that, the court, under the federal rules, was authorized to grant us temporary relief. And that was enough, actually. It was enough to, not that we set out to do it, but looking back on it, I see that the ways in which it was enough to win the media cycle. It also was enough to elongate the time frame available for others to litigate the same ban. And so what happened then is a ton more cases got filed, and they brought different claims. they were before different judges in different jurisdictions. And so now you had a version of what what Bahar was talking about in terms of democratizing the cases, right? Even though all the cases in Guantánamo ended up in the DC District Court, you did have lots of different lawyers taking lots of different approaches. And that turned out to be really important and helpful, because in some ways our case foundered soon after we won our temporary relief, but it created space and opportunity for others to litigate more advantageously in their cases.
Bahar, did you have a gloss?
Sure. I mean, I think it's both hopeful and a little bit depressing. I think my reflection is the media strategy worked and was aligned with the court strategy insofar as there was interest. The true media chase was about the malfeasance of the Bush administration. And it mapped really well with all sorts of other narratives going on: the Iraq War, Katrina, Abu Ghraib. And so, I think people wanted to believe it was true. And so we would tailor our story, not tailor, the storytelling was bona fide and critical for giving voice to individuals in Guantánamo. The themes that came out were, I think, themes people were prepared to hear. Themes about incompetence. We knew the Bush administration was incompetent. Themes about innocence. Everyone wants to hear that story, particularly insofar as it proves the maliciousness and incompetence, and themes about torture. And that was critical for a narrative. But, in the methamphetamine world of, journalistic consumption, I think to some extent, once we won this big case in Boumediene in 2008, and the Supreme Court said, yes, you now have rights, it's really harder to complain that those rights are getting gutted piecemeal in the lower courts, and that people are being left to die. And so it's, both strategic, but, and critical, but ultimately potentially limited.
Ray, do you want to do another CLE at this moment, or do you want to proceed to our next?
Let's go to the next before we go break to Q&A.
Okay, so I think this is just the question about how one does this and what one does when one is burnt out and exhausted and hasn't slept and supervising young attorneys. And this, each of you describes witnessing really harrowing things. And also having really grievous doubts about the legal system as it's currently constructed. So I think I just want to ask the open-ended question. It seems to me that a big part of crisis lawyering has to be taking care of yourself and being sane and suiting up when it's been decades and it feels hopeless. So I wonder if I can just sort of ask, particularly for folks on the call who are thinking about getting into this line of work, the reward is, yay, we got the TRO. The punishment is, as you both said, that doesn't always get you where you want to go. What is the real reward, and what keeps you doing what you do even when you're gutted?
I can start, and then maybe, I mean, I'm going to come at this in a strange way. Look, Munir is very modest about his work in Guantánamo. He was also one of the original lawyers and did absolutely heroic work on behalf of a juvenile detainee who was brutally tortured, Omar Khadr, Canadian detainee, and worked in a genuinely authoritarian system, the military commissions. But I'm remembering, and I might embarrass Munir with this anecdote. We were there together maybe in the summer of 2005, along with Munir's then colleague Rick Wilson, when Munir was at American, and we're in the mess hall having dinner. and Munir gets up to get some dessert, and it's just a military everywhere, a phalanx of Fox News cameras, blaring about the Iraq War, and it felt like we were aliens. And Munir just sort of comes up to us with a Cheshire grin, and he's eating, like, I think it was a Ben & Jerry's Freedom Pop. And there was this sort of moment of hilarity where we recognize there's irony everywhere in Guantánamo, just most of the people don't see it. And I say that because part of the source of sort of sustenance is, solidarity and joy and fellowship and camaraderie around this work, and just unbelievable support and mutuality over the years. I think that's one lesson. You absolutely cannot do this alone. I think even Michael Ratner knew that. The other is, dare I say, part of the confidence Munir had in doing this sort of lightning fast Muslim ban litigation is his experience seeing Guantánamo and what that's like. And I would note, additional relevance. We talked about Michael Ratner sort of being the first to challenge the detention of Muslims in Guantánamo. But as Ray well knows, and Mike Wishney, who is Munir's co-author and partner at Yale, who worked on these heroic cases in 1991, this was not the first time Guantánamo was used as a lawless detention space. It was used after the Coast Guard would interdict Haitian refugees, and the administration, the then Bush, the Clinton administration, said they are entitled to no rights because they are foreigners held on foreign soil. And so there's a sort of continuity and a kind of a sophistication that comes over time with this work, and some sort of confidence. And we all become a bit like sort of repeat players in a system that continues to repeat forms of repression and detention with slight variations. And we can learn from that. And then, of course, I think a healthy perspective as a lawyer, sort of recognizing our place of comparative, as hard as what we're seeing is, comparative comfort or privilege. I mean, most of the time, I think I knew I would leave Guantánamo, or when representing people, subjected to constant stops and frisks, that was not my world. And so appreciating that, and at some level becomes a privilege to stand next to them.
And I just want to flag for listeners that Bahar's chapter ends with a kind of really, I think, lofty set of principles for why we do this anyway. And I think, for young lawyers who feel like sometimes you're just running into a wood chipper, it's a really, really useful, I think, corrective for some of the sense that sometimes this doesn't go the way you want to go, and you do it nonetheless. Do Munir or Lee want to sort of, Munir, you can either file a dissent on the Ben & Jerry's pop, or Lee, you can definitely talk about how complicating it is when you're having to defy the court in order to obey the law. But just sort of last reflections from either of you before we turn to Q&A.
Lee, why don't you go ahead first?
Yeah, I guess I actually would lift up something that Munir said earlier, just about social movements, because I think that, if you are in a lot of the work that we do, we lose a lot. And I think that you have to figure out what's your position, how do you fit into this larger movement, right? And what is the role of a lawyer kind of in support of a movement? I think that so much of what I've learned as a lawyer has actually come from organizers and from people who have a very different way of being in the world and kind of interacting with a problem. And they don't believe in like a linear progression of justice, right? Because we know from history that that's not how things tend to work. And I think that just knowing that and having colleagues that have that perspective is really powerful.
I'll just say briefly, Bahar, I think it was Ben and Jerry's Peace Pops, but the rest is 100% accurate. I mean, there was just the sense of absurdity, which resonated with a lot else that was going on at Guantánamo. And I agree so much with what both Bahar and Lee have said, that sense of camaraderie, the sense of being part of something that is much larger than you are, that has a history. And so Bahar's point about, the work that Ray and Mike and Michael Ratner did at Guantánamo in a previous iteration, and being engaged in work that has a future, which I think a lot about in working with my students who, I should have said at the outset, did the vast majority of the work that we describe in our chapter. That's sustaining in a lot of ways. And Lee's point about losing a lot, I think about a lot too. I often think if we're winning all the time, we're probably not choosing the right cases. And Jules Lebel has a book about success without victory and kind of what the role is of losses, which I think resonates a lot with much of what Bahar was saying. And I think that it's a question of actually of how we think about what counts as success. If we place all of our hope for change in the courts, we are setting ourselves up for disappointment, and we know that. So I think that the question is, what are the ways in which we can meaningfully and honorably engage in litigation or other aspects of lawyering, while being clear-eyed about what the limits of our success there can be, and thinking about what is it that enables success more broadly. And I think I agree with Lee, it comes back to kind of thinking about who are the other actors who are engaged, how are the ways in which we kind of build, how people are building power or mobilizing folks in support of ideas for progress and equality. And much of that, I think, does come back to organizing.
These are amazing answers. Ray, do you want to hold up the CLE? I feel this is the Vanna White portion of the show.
Absolutely. So it's rights to. Second code is rights to. I'll put that in the chat as well.
And I'm going to take some questions from the Q&A, I want to start with this one, again, for the whole panel. It says, law student here, thank you so much for making this event public, reminding me why I went to law school. I'm curious what best prepared you to engage in crisis lawyering, or better, knowing what you know now, what advice would you give your younger self at the outset of your legal career? Who wants to do letters to a young crisis lawyer?
I'll just start and say something very briefly. I actually think, so I'm a former journalist. I was a journalist for many years, and I think that was actually super helpful for preparing me for crisis lawyering, because I was in a crisis newsroom for so many years. And I think the other thing that prepared me was actually being a mom. I started law school while nursing a 9-month-old. And I think that having a baby while in law school also sort of, gave me a sense of perspective, which I think is so easy to lose when you're in law school. They just rob you of that. So try to keep the perspective.
Any other thoughts from our other panelists? Yeah, go ahead.
I think I would just underscore what Lee and Munir have already said, which is, prepare yourself. Think about lawyering as one that does not regularly expect a victory in the courts. I think that that's the through line for all all our cases, and that therefore requires really deep thinking about multidisciplinary strategies to attack injustice through partnering with movement organizations and activists, and supporting their likely more durable calls for social change, engaging in broad advocacy campaigns and public education and the media, and just to really think critically about that. And then sort of, I think, continuing to develop habits of reflection and consistently asking yourself about the work you did, what would you do better, who else would you partner with, and then find a support network. Again, the best part of this, I've been doing national security work for 20 years and this is exhausting, but the thing that still feels gratifying is we've sort of been in the struggle with some of the same people over time, and that's really incredibly nourishing.
There's a question for the panel that says, for Gitmo, IRAP, airport detainee, other movement moments, pro bono attorneys eager to help sometimes are unfamiliar with lawyering and can be a challenge to manage. This dovetails with some of Munir's chapter 2 about trying to teach students in a clinic who are learning on the fly how to do things in really exigent circumstances. The question is, they're very valuable, but thoughts for how to kind of help really eager and willing pro bono lawyers who are rushing in to the breach, how to manage them and help them be the best lawyers they can be.
But Bahar, you had 1,000 volunteer lawyers? I think you could speak to this.
Yeah, so we recruited thousands of volunteer lawyers, and it became loosely called the Guantánamo Bar Association around Guantánamo. But I think these partnerships can be incredibly effective. But in my experience, we work with a lot of law firms in a range of cases, stop and frisk and border challenges. And I think those are really important moments that sort of teach them that. And I think, in private practice, maybe they're used to winning, and recognizing that leverage and resources translates into winning where it was different. So I think conversations about and concrete examples about how to structure a litigation that supports the movement can actually strengthen the core aspects of the litigation. And I think that's actually a conversation I do, and I'm happy to do it while Miriam, with lots of law firms from various examples we've worked on.
Munir, Lee, do you have any thoughts on managing pro bono lawyers?
What I would say is that I think that so again, I think is one of the through lines in our chapter is that it's very hard to innovate in the moment of crisis. It's true, as you were saying earlier, Dahlia, is a million decisions that you're making without, I appreciate your kind of framing of it as without knowing what the cascade effects are. And so what that means necessarily is that you're drawing upon a toolkit that you've already assembled because you can't do it in the moment. And I think that is generally true with regard to how to incorporate lawyers from other cultures, including pro bono lawyers from firms. In the moment, kind of in the heat of it, I think there's not actually the time or the resources or the headspace, frankly, to acculturate to the role of movements. But over time, I think that there is, and this is outside the bounds of what we wrote about in our chapter, but we've been involved in the DACA litigation for the past many years. And that's another case where there's a huge kind of assemblage of different kinds of lawyers and social movement actors. And one of the things that I'm consistently impressed by there is the dialogue between the movement actors, the organizers, and the law firms. And I won't accept myself from that. Just the lawyers. The difference in, we all kind of, just by virtue of being lawyers, we put on a set of blinders. And even as we might kind of align ourselves with social movements, align ourselves with organizing, the reality is that there's certain kind of disciplinary demands. I mean, this resonates with Lee's chapter also, right? By virtue of the roles that we have, that influence our thinking, may not determine it, but do shape it. And having a completely different starting point from movement actors and having them in regular conversation or dialogue with the community of lawyers over time, I think, can have a real influence. So that's a long way of saying that you might actually need non-crisis circumstances in which to kind of achieve that kind of cultural alignment. And you either need to do it beforehand to have kind of long-standing relationships, or you need to project forward and think about an investment in those lawyers who kind of rush into the breach in the moment. Can you hold on to them when things like Guantánamo happen and the crisis becomes stasis?
That actually is a great segue to a question that's surfaced in the chat and in the Q&A, which is, what do we, as a panel of crisis lawyers, tell young lawyers who are looking at the crisis at the border? And crisis at the border, it's complicated. But I think that that's another area where there has been, what with family separations, and now another administration that's going to have to figure out new policies, a real impulse to go down and work with migrants and hunker down in Texas and figure it out. What advice could you each give to young attorneys who are moved to do that, with the understanding they may not have the background in immigration law, they may not understand all the nuance of the situation, but they really, really want and need to help? Advice from your own experience. Munir, I'm so mindful of you saying, it just doesn't help to reinvent the wheel every time. The whole sort of point of both the book and this panel is to figure out through lines. What's a through line here for young lawyers? I'm sure there are some even on this call who are moved to do that work.
Well, I want to hear from others, but I'll just say very briefly, and this is in some ways from the perspective of being my day job is as a teacher. I think that understanding that when you become a lawyer, you're not kind of acquiring a finite amount of knowledge and then starting to apply it, but in fact, you're in the early stages of a lifelong process of learning is a really important kind of orientation. And what Bahar said earlier about reflection in clinical teaching, we talk all the time about as critical reflection, I think is the engine for personal and professional growth for a lot of lawyers. And so in the specific example, I would say, go do it. If you have the time, the energy, the means to kind of do it. But think of it as not, I'm going to go and do this for a week or a month, but I'm going to go, and as you said, Dahlia, try to figure this out. And figuring something out like what's going on in the border will necessarily invest you not just in what's been happening since January 20th, but actually what's been happening for hundreds of years, and will equip you then to imagine how it might look different. That is a creative exercise as much as it is a kind of a technical exercise of bringing your law degree and your ability to file papers in court. That is, it can be, I think, quite frightening to step into something like that. And I guess what I'd would say, to pick up on the themes that we've talked about earlier, is you won't be alone. You will find and make what I predict would be lifelong friends, allies, colleagues of the kind that Bahar was describing earlier, and the kind that I think we all experience. And something like that could end up being, a life-changing event for you. And I would just embrace that with a sense of adventure and the sense that you are on a lifelong journey.
Lee or Bahar, do you want to kind of give a last thought or reflection on either kind of advice to young attorneys or just stuff to think about for people who think you're fierce and fantastic, but they couldn't possibly do what you do? Lee, you want to take a crack at closing us out?
Oh my gosh. I'm really not up to that, but I guess I would just observe that, in thinking about the crisis at the border, that is really a repetition of previous crises. We're not out of it, right? I mean, the crisis is not over because we have a new administration. And I think that it's just really, this sort of goes back to the themes of really understanding the history and understanding movement building. It shouldn't surprise anyone that this is returning as an issue, right? I think that, and I think that it's sort of, I would say that in addition to going to the border and volunteering and opening yourself up to that new experience and figuring it out, your community, the community that you live in, more critically, and ask, what is happening right here in my own backyard? Because it is likely happening right around you too, right? So, and it will continue sort of regardless of who's in power, because these ideas are so, the pathologies that underlie all of this are so persistent.
I really love what Munir and Lee just said. And maybe to sort of tie them together, I love, Munir's suggestion that you go in with a sense of an adventure and from a place of learning, an openness to learning, thinking that this is a first step in a lifelong journey of sort of responding to various forms of government repression. And that, that ties to what Lee just said. This is not new. And these systems aren't new. And I think that's been another one of these through lines. These practices are so deeply rooted in the American conception of power and exclusion. And that, coming back to my first lesson that I learned when I started this work, maybe 4 or 5 years out of law school, thinking Guantánamo was exceptional. I now know it isn't. I now know Guantánamo is everywhere, and the border is everywhere, and detention is everywhere. And we have to think strategically about how to dismantle those systems and not expect that we can sort of parachute into the border. And of course, there's a lot you can do. That's harm remediation. That's incredibly important. But this process of lifelong learning and reflection is a really powerful one.
That's such a profound place to end, and maybe lash together, Bahar, with your reflection in your chapter that every time we say this is not America, we end up eating crow, because in some sense that is part of the problem as opposed to the solution. It has been a phenomenal honor to be with all of you today. The book is tremendous, and I want to congratulate all of you, not just for your chapters, which I think will shine a light on a lot that we don't know as lawyers, but on the work that you do. So I want to thank CCR. I want to thank Albany, Ray, Munir, Lee, Bahar, all of the good folks who have hung out with us this evening. I am, on behalf of this great panel, saying thank you and be well.
Thanks, everybody. Have a great night.
Ray, there's a question about the name of the book. Can you put it in the chat quick?
Crisis Lawyering, NYU Press.
The book is Crisis Lawyering. And do we need a third code, they're asking in the chat?
Nope.
Nope, just the
Just the
two
two.
codes, folks. You're clear. Thank you. Good night.
Good night, everybody.
Thanks. Bye.